Thank you for joining us today. The program is about to begin. Please make your way to your seats and silence your cell phones. Please take your seats. The program will begin momentarily.
Good morning, everyone, and thank you to this, welcome to this Aspen Ideas Health session called When Healthcare Goes to Court, where we will be discussing the health docket of the U.S. Supreme Court this term and what may lie ahead. My name is Kimberly Atkins-Storr. I am a columnist and senior opinion writer for the Boston Globe. I'm also an MSNBC contributor, and I am co-host of the podcast #SistersInLaw. And I could not be happier to be joined on this panel by two esteemed Supreme Court experts who are going to be the arbingers of the wisdom that you're going to get today. I will just be the traffic cop. They are really who the show is, and they are also two friends of mine who I've known for a very long time. Canon Shanmugam is a partner at the law firm Paul Weiss, Rifkin, Wharton, and Garrison, where he chairs the Supreme Court and appellate litigation practice. And Melissa Murray is a law professor at New York University, also co-host of the very popular podcast Strict Scrutiny, and is also an MSNBC contributor with me. Their full bios are in your materials. It would take most of this panel just to recite all of their accolades. So I'm just going to get started. This was a Supreme Court term that started still in the shadow of the Supreme Court's massive healthcare ruling in Dobbs, which overturned Roe v. Wade 2 years ago. Given that and other aspects of the court, I think it's a good way to start this conversation by saying how it started before we get to how it's going. So I just want to start with both of you to give some thoughts about the term overall. I'm going to start with you, Melissa. Sort of what are your overall thoughts as to where the court found itself at the beginning of this term in terms of where healthcare is in America?
So thanks for having us. It's great to be here this morning. And let me just sort of set the stage a little bit. As Kim said, it's been 3 years since the court decided Dobbs versus Jackson, Women's Health Organization. It was decided 3 years ago yesterday. That was the decision that overturned Roe versus Wade. It's also noteworthy because it was sort of an introduction to what would become a pattern of this court with its 6-3 conservative supermajority, which is to say, in all of the 3 years in which the court has had that 6-3 conservative supermajority, it has overruled a major precedent. So in 2022, it overruled Dobbs. In 2023, it essentially overruled the entire line of affirmative action precedents. And then last year, in 2024, it overruled Chevron versus National Resources Defense Council, a major administrative law precedent that has enormous impacts for all regulated industries, including the healthcare industry. When this term began, though, it looked a little sleepier than previous terms, and that likely was also by design. The Supreme Court has lots of discretion to select its docket, and when the docket was sort of put together, when it sort of materialized around October, it seemed like the court had been pretty sparing in what it had selected to review for the term, and that might have been because it was anticipating some spate of election-related cases in the run-up or in the aftermath of the 2024 presidential election. Now, that did not materialize, and shortly thereafter, we had the court adding to its docket, including a number of cases that were actually quite significant and that would have some implications for health. But to my mind, the health docket, as you want to construct it, is really a lot of administrative law cases that really go to this broader question of whether or not the court is receptive to the prospect of the administrative state, of this idea of administrative agencies making decisions in the shadow of executive power, and to what extent the court is interested in, as it was last year in the case that overruled Chevron, in curbing the power of administrative agencies. And I think that's a big part of how this healthcare docket has been shaped and will be shaped as the court's term winds to a conclusion.
Canon?
So first of all, thank you for having me. It is a great pleasure to do this panel along with Kim and Melissa. And let me offer some general thoughts, and then we will, of course, turn to the healthcare docket, which I think we're going to have to broadly define so that we have enough cases to talk about. We are at a very unusual moment, I think, for the Supreme Court. The court has, over the last few years, issued a number of obviously very significant decisions. I tend to think that this is a bit of a breather year for the Supreme Court when you look at the court's docket. Really, with the exception of the decision in Scrimeti, which we'll discuss, and the upcoming anticipated decision in the CASA case on nationwide injunctions, we do not have the sort of blockbusters that have really come to exemplify the court over these last few years. The court is on course to issue somewhere around 58 decisions on its merits docket. That is pretty typical for the court, and although the court has around 10 decisions left, the court has had only 4 6-3 decisions on its merits docket so far, and only one in which it was divided on so-called ideological lines with the Republican appointees in the majority, the Democratic appointees in dissent, and that was, of course, the Scrimeti case, which we'll turn to in a minute. Now, why is the court taking a relative breather? To some extent, the court's docket is dictated by the cases that come to it. But I think, as Melissa rightly said, I think at the beginning of the year, I think that the court was a little bit reluctant to go out and grant a lot of cases because of concern that the 2024 election was going to end up on its doorstep. And then, since January the 20th, I think that the court really has been leaving space for the so-called emergency docket, or shadow docket, if you prefer. And what do we mean by that? Those are the cases that come to the court on emergency applications, typically for injunctive relief. And by and large, over the last decade or so, that docket has come to be dominated by challenges to actions taken by the administration that is then in power. And because this administration is using the executive power so muscularly, we have seen literally dozens of cases in the lower courts involving challenges to President Trump's actions in various forms, and those challenges have been making their way up to the Supreme Court in droves. And unlike the traditional merits docket, those applications can come to the court at any time. The court often feels exigency to act on those applications. We've seen post-midnight rulings from the Supreme Court. And if anything, the emergency docket has come to dominate the headlines. And in some sense, the traditional docket, where parties take months to go to the Supreme Court, where cases get leisurely briefing and then oral argument, has felt at times almost like an afterthought. And on that emergency docket, we have seen some of the more traditional division between the more conservative and more liberal justices. It doesn't always break down predictably on those lines, and I think one of the interesting trends we've seen this term is Justice Kagan sometimes not joining the more liberal members of the court, Justice Sotomayor and Justice Jackson, both on the emergency docket and on the merits docket. Mm-hmm. But I think more generally, we have seen the court really trying to kind of navigate this unprecedented moment where we have an administration that is using the executive power very broadly, that has been very critical of lower court judges that have ruled against it. And it feels like that is really where all of the action lies. Less activity with regard to healthcare on the emergency docket, but a lot of activity with regard to the scope of the president's powers.
And I think the point that you made about the pending ruling, which is a shadow docket case, but I'm expecting it to be decided by the end of this term in opinion form, because often shadow docket cases just end with an order that doesn't necessarily even include an opinion at all. But that is the nationwide injunction case, and just a lot of healthcare cases have involved that. The mifepristone case from past term involved a single judge in Amarillo, Texas, essentially trying to remove FDA approval for mifepristone. In COVID, we saw a lot of health-related nationwide injunctions as well. So that is also a health docket case without being a health docket case, right?
No, I think that's right. And I think, we've been talking about it as the nationwide injunction case. I think it is more colloquially known in general parlance as the birthright citizenship case. Yes. The court, and you should know all of this, when that decision comes down, and it is likely to come down at the end of this month, in large part because the court almost seemed to migrate it to the merits docket and called for full briefing, which is not ordinarily what they do with the emergency docket cases, but the court called for briefing and really narrowed the scope of the question. So the question that they will be answering is not whether or not the 14th Amendment's first section grants explicitly birthright citizenship to those born on U.S. soil. It will be this narrower procedural question of whether federal judges, as part of a remedy for a constitutional violation, may impose a nationwide injunction stopping a government actor from doing something throughout the entire country rather than in their specific district. So it is a broader case with broader constitutional questions, but that broad constitutional question is not the one the court will answer. And it's really important for you to know that, because our colleagues on MSNBC and CNN and everywhere else will say that the court saved the 14th Amendment. The court didn't touch the 14th Amendment, and it will not touch the 14th Amendment. That broader issue will be deferred to a different case. Instead, the court is going to decide this narrower question of whether or not the nationwide injunction is an appropriate remedy for a constitutional violation. And that will actually have huge implications, not just for health, but everything, because right now a lot of the administration's actions are being challenged. These executive orders are being challenged, and lower court judges are dealing with them by either allowing the administration to continue, or stopping them by imposing a nationwide injunction. So if the court limits the availability of the nationwide injunction, that will make it harder for lower courts to stop the administration from doing things that the court believes is unconstitutional.
Yeah, I mean, I think what's really interesting about the nationwide injunctions issue is that this is an issue that has really bedeviled administrations of both stripes.
Right.
And in the last administration, you had exactly the same dynamic that we're seeing here. The president takes unilateral action. Plaintiffs challenge that action. The plaintiffs tend to choose forums that they think are going to be sympathetic. And sure enough, they are able to get broad relief from the lower courts. And when plaintiffs do that and get broad relief against major administration initiatives, it puts tremendous pressure on the administration to then take it all the way to the Supreme Court if necessary to get out from under that relief. And so one of the few things that might unite the Biden Justice Department and the Trump Justice Department is their hostility towards this practice of nationwide injunctions. And you've had solicitors general of both parties taking the view that there have to be some limitations on lower courts entering those temporary injunctions.
Although it is worth noting that the court could have taken up this question of whether and in what circumstances the nationwide injunction is an appropriate judicial remedy at any point that this question has been raised, like during the Obama administration, during the first Trump administration, during the Biden administration, but it chose to do it now.
Which is so odd. This case, the birthright citizenship case, I thought was an interesting one.
An odd vehicle for this, yes.
It is, because the Trump administration took great pains not to present the underlying substantive issue of the validity of the executive order on birthright citizenship to the court. It said
because they can't win, because they cannot win on that issue. Because
as was suggested,
reading the 14th Amendment.
As was suggested to them at the oral argument, and I think one of the interesting things to watch will be the extent to which those underlying merits nevertheless infect what the court does. And this has tremendous broader significance, because the reality of modern day America is that we have a Congress that is out to lunch or something else, and therefore presidents sooner or later come to the conclusion that if they want to implement their policy preferences, they have to do it through some form of unilateral action, whether through executive orders, regulations, and the like. And that has created this great tension that we are now seeing between the executive branch on the one hand and the judiciary on the other, because the judiciary is the only meaningful check on the executive branch. And so you saw the Supreme Court at the oral argument in this case really struggling between, on the one hand, wanting, I think, to rein in this practice, which has put tremendous pressure on the lower courts, but particularly on the Supreme Court, causing them to have a lot of these late nights. But on the other hand, recognizing that if you have an administration that is seeking to press its policy preference aggressively, and courts don't have the power to enter nationwide injunctions, you have a whack-a-mole problem where administrations could simply litigate on a case-by-case basis the validity of this practice, which makes it very difficult for the judiciary to impose its will. And so it's going to be really fascinating to see how the Supreme Court resolves this, and it's going to have implications for every substantive area of the law.
And I think that is a good exemplar of how the Supreme Court's health docket doesn't really look like health, but those are the cases that are really going to affect health policy on the ground. So now turning to the actual cases on the docket that are health-focused, the biggest on the term has already been decided, and that is a case in which the Supreme Court upheld Tennessee's ban on gender-affirming care for trans youth. I will start with Cannon just to describe what the court did a little bit, and then we'll discuss it a little more.
Sure. So this is a case involving a Tennessee law that restricted medical treatments for transgender youth who wanted to have these treatments to align with their preferred gender identity. It is one of, I believe, 22 states that have similar such laws. And the case has kind of an interesting procedural history because the law was immediately challenged by private plaintiffs who wanted to get this sort of treatment, who were restricted by this law. It was challenged on multiple grounds. The primary ground that went to the Supreme Court was whether or not it violated the Equal Protection Clause because the law discriminated either on the basis of sex or transgender status. Now, what made this case procedurally interesting and a little bit complicated was that the Biden administration then intervened in the case. And when we talk about intervention, what we really mean is that the United States, through the Biden administration, became an additional plaintiff in the lower courts. So you had the United States and these private plaintiffs both challenging Tennessee's law. In a decision written by, I think, perhaps the most respected Court of Appeals judge in the country, Chief Judge Jeffrey Sutton of the Sixth Circuit, a divided panel of the Sixth Circuit upheld the law, applying the lowest form of constitutional scrutiny, a type of constitutional scrutiny known as rational basis review, and concluding that Tennessee had a rational basis for the law. The private plaintiffs and the United States government both went up to the Supreme Court and sought review, and somewhat oddly, the Supreme Court granted the United States' petition for review, but not the private plaintiff's petition for review. They were raising somewhat different questions, and we could get into that, but for purposes of this presentation, the issue that was presented to the court was this question of whether or not it violated equal protection, and the Supreme Court ultimately, by a 6-3 vote, held that it did not. Now, one of the oddities of this case was that the case was argued, I believe, in December before the inauguration of the new president. After the inauguration, the new president promptly said, the position of the Biden administration is not our position, but you might as well go ahead and decide this case and overlook the fact that it was the United States that sought Supreme Court review in the first place, which the court promptly proceeded to do. So, on the merits of the case, I think what is most interesting, and I suspect Melissa may have somewhat different views on this, but what I think is most interesting about how the court decided the case is that in the majority opinion written by the Chief Justice, the court basically said these laws do not discriminate on the basis of either sex or transgender status. And because of the absence of discrimination, we're going to apply rational basis review. And that allowed the majority to dodge the question of whether or not laws that discriminate on the basis of transgender status are subject to the type of heightened scrutiny that laws that discriminate, for instance, on the basis of race or on the basis of sex are subject to. And the court therefore left open the broader constitutional question of whether or not transgender individuals are entitled to the same sorts of protection. And the court, in doing so, had to, I think, sort of weave a path through the law to conclude that there was no discrimination. And interestingly, Justice Alito, who joined the majority, got off the train on the question of whether or not there was discrimination on the basis of transgender status. Instead, he, like, interestingly, Justice Barrett, would have gone further and said, no, there is no heightened protection for transgender individuals under the Equal Protection Clause. And so I think in some sense, although this was a loss for the transgender community, it was not nearly as big of a loss as it could have been if the court had gone on to reach that issue. The other I would just add one other thing, which is that for people who are interested in this, there is a very long New York Times article about the background to how this case was litigated. I think it's a fascinating article. It really takes a deep dive into the transgender rights community, their approach to this litigation, the approach of the Biden administration. I think in many ways one of the most interesting and broader questions that this case presents is, what do you do with evidence concerning the healthcare implications of a law? This was a case where the transgender community came in and said, look, there is overwhelming evidence that these sorts of laws are necessary to protect the health of transgender minors. It turns out that there were some very substantial holes in that evidence. Justice Thomas wrote an entire opinion about this, but the New York Times article also points out that this evidence was, I think, to some extent litigation-driven, and I think that the court's opinion in this case, which is not unlike some of the court's opinions in the area of abortion, really takes the view that these sorts of evidentiary questions are really questions for legislatures in the first instance. And I think that that is an issue that comes up time and time again in a number of healthcare contexts where you have laws that are based on assumptions about the evidence.
All right, I just want to get Melissa in here so that we can get through everything. And I want your take on this case. Scrimetti is the name of the case. But I also want you to address the fact that Justice Neil Gorsuch, who was in the majority, had very recently authored an opinion called Bostock, in which he said that under Title VII, the employment discrimination law, the federal employment discrimination law, that bars discrimination on the basis of, among other things, sex, gender, includes a prohibition against discrimination on the basis of gender identity or sexual orientation. So how did Gorsuch square that? And give me your other thoughts on Scrimetti.
Okay, so Cannon is right. I totally disagree with much of what he said. So we still love each other, but I'm going to set it out differently, I think. So the Tennessee law prohibited certain forms of medical treatment, but only in certain circumstances. So it would not allow boys to have puberty blockers if those puberty blockers were to stop the onset of male puberty. By the same token, it did not allow girls to have puberty blockers if those puberty blockers would be used to stop the onset of female puberty. That's clearly a sex-based distinction. You can use this therapy for anything else except stopping the onset of the physical manifestation of your gender as identified at birth. That is a sex-based distinction. It is also a distinction that uniquely targets those individuals who identify as transgender. And that was the question. If this is a sex-based distinction, if it is a distinction that turns explicitly on the question of the sex of the person, if I am female and I want to use puberty blockers to just minimize my periods, whatever, I'm fine to do it. I can use it for that. But if I'm a female and I want to use it to stop the onset of puberty entirely so that I can transition to a different gender, that's not permissible. That's a sex-based classification. And the way I know that is because I can read. I can read this law and I can read what it says and I can draw conclusions based on that. That's the whole question here. How do we determine what is a sex-based distinction? How do we determine what is a distinction based on trans status? The court here says that there's no sex-based distinction, that instead this law turns entirely on questions of age, the fact that it targets youth particularly, and medical use, two different uses. It never even admits the possibility that laws can target on a number of different axes: race, sex, youth, status, all of this. All of these things can happen simultaneously. So the court takes a very narrow view of this in order to then apply the lowest level of constitutional scrutiny, the most deferential form of constitutional scrutiny, and to find for the state. They say that this is an issue where medical evidence seems to be uniquely contested. And in those circumstances, as in the context of abortion, those kinds of fraught, debated issues should be reserved for the legislatures and not for the courts. And so this gets sent back to the legislature to make this decision. The point that Cannon made about medical evidence being debated, I think, is a really important one. Justice Jackson, in oral argument in this case and in just her discussions with the lawyers, mentioned the fact that in the civil rights era, the question of whether interracial marriage had deleterious health and social impacts was a major question in which the medical community was deeply involved and where there was a lot of debate and disagreement. Some people saying that it was terrible for blacks and whites to intermarry, other people saying that it was perfectly fine. If we were to simply consign the question of an individual's rights to the democratic process because the medical community debated something or found disagreement on a particular issue, we would be consigning almost every underrepresented minority's rights to the political process. And in this particular case, where trans individuals are about 1% of the population, it means that if we turn their rights over to the political process, they aren't likely to win. They don't have the numbers to win. And so in those cases, the court typically takes on the role of protecting underrepresented minorities by reviewing the government's actions against them more strictly, the heightened scrutiny that Cannon mentioned. But here the court says, we're not going to do that. We're going to defer to the legislature, and we're going to allow this law to stand. Kim asked me about Justice Gorsuch, who wrote that earlier case in 2019, Bostock versus Clayton County, which said that discrimination on the basis of sex includes discrimination on the basis of sexual orientation and gender identity for purposes of Title VII, the Federal Civil Rights in Employment statute. Justice Gorsuch was silent Bob in this case. He did not speak at oral argument, even though he had authored the most pertinent decision on the issue. He did not write in any of these cases, although he joined the majority. So I don't really know what to say about Colorado's favorite son. He had nothing to say in this case that was essentially about the most consequential decision of his entire career on the court. I will note that this case has really huge health implications, not just for transgender youth. In red states, which are passing these laws at an alarming clip, roughly 23 states have these prohibitions on gender-affirming care for trans youth. It will mean that trans youth and their families will have to go to other states where this medical treatment is available. That will increase demand in those states where it continues to be available, which will have real consequences for everyone who's seeking that kind of care. It also is susceptible to executive overreach. So we have an administration that has already come out with a series of executive orders declaring that the only genders that exist are the biological genders, and those are the only genders that will be recognized. So the idea of trans status is not one that this administration favors, and in fact, there's deep antipathy for the question of trans identity among those in the administration. If that is the case, and this administration takes steps, for example, to restrict federal funding for hospitals that provide gender-affirming care, whether to adults or to minors, that means the accessibility of this care is going to shrink further. And if the administration takes those steps, it can use this case as emphasis, as a rationale for why it is proceeding in a constitutional fashion. So yes, this case could have been worse. We could have had a majority decision that said very clearly, as some in the majority wanted to, that transgender identity is not a protected class under the Equal Protection Clause, but it's still a really bad decision for trans youth and their families who have relied on this care since it's been available in situations where children have been deeply traumatized, maybe even suicidal, over the question of gender dysphoria and gender identity.
Let me ask a question about how the impact beyond families with trans youth. To me, reading this opinion, the biggest question I had going out is, well, what about parental rights, which is a strong, something that conservatives in particular have been pushing very strongly in court cases, the need for parents to be able to make decisions about the well-being of their children. There are other cases, including a case about books in schools, that really turn on this. To me, this case seems to really set that back, that sets back the ability for parents to decide the health care of their children, not just in this context, but far beyond.
I mean, I was just going to say, fascinating that the court didn't take the question on parental rights, which was presented by the private plaintiffs, and not by the government for Supreme Court review. And the articles suggest that there was a lot of debate about whether to raise that issue before the Supreme Court, but I do think that the court sooner or later is going to have to confront that issue.
You know, the issue is definitely coming back again. It was really interesting that the court did not pick up the question of parental rights. Under the Due Process Clause of the 14th Amendment, the court has interpreted the Due Process Clause to find that parents have a fundamental right to raise their children in the manner of their choosing. It is not an unfettered right. It is subject to some restrictions, like you have to send your children to school, you cannot make your children sell drugs or whatever. Like, there are limits on the fundamental right of parents, but this idea that parents can make medical decisions for their children, that is well within the realm of this fundamental right. And the parents below in the lower courts had advanced this. It had been addressed, and I think the Sixth Circuit decision kind of gave very short shrift to the prospect of parental rights, which is, you know, one reason why I think that decision is deeply, deeply problematic. Kim is exactly right that parental rights is a double-edged sword because, yes, it can be used to articulate a demand for certain kinds of care on behalf of children, but parents have also used it to argue against mask mandates and vaccine mandates. And there is a case right now pending before the Supreme Court where parents who are religiously conservative argue that certain kinds of book choices in school curricula violate their rights to raise their children in the manner of their choosing. What is interesting about this case is that merely weeks after the court heard the oral argument in Scrimeti, where it seemed to be entirely inattentive to the desires of parents to raise their children in a particular way, the court seemed to embrace this question of parental rights in the context of these religiously conservative parents, and they accepted that case, Mahmoud versus Taylor, to be reviewed, and we're still waiting on a decision in Mahmoud.
So I want to talk about a few other cases on the court's docket, but while still leaving plenty of time for you all to ask questions. So have your questions ready. We will turn to those in about 6 or 8 minutes or so. But I want to move on to another case that will have pretty big implications, actually a pair of cases on vaping. Melissa, you want to explain those and the healthcare implications of those?
So these two cases involve e-cigarette manufacturers and the FDA, and I think I would group these in the larger administrative law bucket, whether this court continues to have deep antipathy or skepticism of the administrative state and administrative agencies making regulations that may hem in certain industries, including the e-cigarette industry. In this first case, White Lion, the court was faced with the question of an FDA denying a permit application by a pair of vaping companies to sell their products in certain venues. And the reason why the FDA denied the application was because they believed that the manufacturers had not shown that, one, the manufacture of flavored vaping liquids would pose a public health benefit to adults, and they worried that they would be unusually attractive to youth, and that would increase the likelihood that youth would use this. So in that case, the court actually said that the FDA had the authority to deny those applications. So it seemed like the court was perhaps, maybe okay with the prospect of some FDA regulation. But then there's this second case that was decided shortly thereafter, and it's a very procedural, technical case. RJ Reynolds, which is a major tobacco manufacturer that now has a vaping arm, wanted to challenge an FDA regulation, and the statute says that those cases have to be brought in the District of Columbia Circuit, where most agencies are located, or in the home circuit of the company. In RJ Reynolds' case, that's in North Carolina in the Fourth Circuit. But the Fourth Circuit had already issued a ruling that had been very inhospitable to the prospect of vaping and selling vaping materials in various venues throughout the United States. So it was not a very hospitable venue for the manufacturer, nor was the DC Circuit, because the DC Circuit tends to be more hospitable to the agencies. So RJ Reynolds decided to get one of their retailers, which was located in Mississippi, and another trade association located in Texas, both in the Fifth Circuit, a circuit that is perhaps more amenable to the needs of regulated industry, and they decided to bring their case there. And so the question before the court was whether or not the FDA statutes would allow a manufacturer or a company to join in with another retailer in order to shift the venue to another location. And so although the court was amenable to the FDA in the first case, in the second case, it said that the FDA statute would allow the manufacturer to work with a retailer and then bring the case in a different circuit or a different venue, one likely more hospitable. That's really significant because even though the FDA can still regulate the vaping industry, they're more likely to be challenged because now the manufacturers can join with retailers in more hospitable circuits to file their cases in places where the FDA's regulations are more likely to be challenged successfully.
Can I make a very quick observation on this? I know we've got a couple of other cases we want to cover. My observation is that one of the overarching issues right now with the Supreme Court is the Supreme Court's view of government agencies. And in a case last year called Loper-Bright, the court essentially said government agencies get no deference in their interpretations of federal laws. Nevertheless, this year, what we have seen is in the context of very specific applications of that principle, we have seen the court granting deference to the government. In the White Lion case regarding e-cigarettes, in the so-called ghost guns case, Vanderstock, involving the interpretation of the federal firearms laws. And I think that we are going to see the Supreme Court beat back a challenge under the so-called non-delegation doctrine, which is another avenue that has been used to limit the powers of administrative agencies. At the same time, what we've seen is the court taking a somewhat broader view of who can bring challenges and where the challenges can be brought. And that's the R.J. Reynolds case that Melissa referred to. There was also a big case on standing, the ability to bring suit, the Diamond case involving fuel producers. And so, you know, I think that this is an area to watch, and it's an area of obvious significance, particularly as it pertains to regulatory areas like Medicare and Medicaid. I do think that those are areas in which, because of the technical expertise of government agencies, the government does get a certain degree of practical deference that it might not in other areas, but that deference is clearly not unbounded.
And I just want to also touch on another case, Medina versus Planned Parenthood, South Atlantic. Cannon, you want to?
I think this is a sleeper case before the court. The court has not yet decided it. The court tends to leave the most contentious cases for last. We may see a decision this week, and it essentially involves the question of whether private parties can bring suit under the Medicaid statutes on the theory that they are being denied treatment by their preferred provider. In this case, Planned Parenthood, which was essentially rejected as a provider by the state of South Carolina under the cooperative federalist scheme of Medicaid. And the question in this case is whether or not private plaintiffs, so patients, have a right of action to sue on that ground under the Medicaid statutes. Now, what's interesting about Medicaid is that it does not provide, in so many words, a right to sue on this basis. Instead, it contains somewhat squirrelier language that basically says that, you know, anyone who is covered by Medicaid can be treated by essentially anyone for a provided service. And the question is whether or not that is functionally the equivalent of rights-creating language. And there was a lot of back and forth at the oral argument about how much is required in order to confer such a right. Interestingly, Justice Barrett seemed to suggest in some of her questions that she might think this language was sufficient. Other of the Republican appointees on the court, I think, took the more rigid view, and so clearly this is going to be a divided court, I think, in some way. The general direction of travel has been away from so-called private rights of action. So I think the smart money is probably on the court saying that there's no right to sue here, but that's not a very confident prediction.
Melissa has thoughts.
So I do have thoughts. The Medicaid statute, like a lot of these statutes that were passed under the auspices of Congress's spending power, were passed in the 1960s. They don't have explicit language creating rights, like I create a private right for you, the eligible person, to sue when your right under this statute is violated. But the court has, over the scope of the 50 years that those statutes have been in place, construed a private right of action for individuals who are eligible under the statute to sue when they don't get the treatment that they would like. And in fact, just 2 years ago, in a case involving the Federal Nursing Home Reforms Act, the court held, the case was called Telefsky, that even though there was no explicit rights-bearing language in the statute, nonetheless, a public beneficiary of the statute, here an individual who was in a public nursing home, had a private right of action under Section 1983, the Federal Civil Rights Statute, to sue the state for violations of the statute. And so, yes, this court has been narrowing the availability of rights of actions to sue under these public welfare benefit statutes, but that actually goes against the longer trajectory in which the Supreme Court writ large has actually allowed this to happen, because this is the way private individuals are able to exercise their rights. It is unlikely in circumstances like this that the state who is administering the home is going to sue itself on your behalf because you're not getting the care that you are eligible for. So it makes sense that individuals should be allowed this private right of action, and that traditionally has been how the Supreme Court, before the Roberts Court, has approached it.
So I want to open up the floor for questions. There are a couple people who can come around to you with mics. Please make sure that you have the mic before you start asking your question, and we'll start over here.
Thank you. Thank you so much. Fascinating conversation. My question for you is a little off of any specific case or application, but it's about sort of how the Supreme Court is perceived. There's a lot of commentary right now on MSNBC and elsewhere about loss of trust in the court, the sway of public perception, and I'm just curious on your thoughts of how much that matters.
Can you start?
I gave a whole speech at Duke Law School on this subject last year, so I'll summarize it in about 60 seconds. Look, I think that there is no doubt that those who disagree with the court's decisions have been very critical of the court, and I think one of the ironies of the current moment is that we're now seeing exactly the opposite dynamic in the lower courts, where we're seeing the Trump administration now criticizing the lower courts in similarly personal terms, perhaps even more so. And I personally think all of this is a little bit unfortunate, but it is reflective of the fact that we live in this incredibly politicized moment, and the Supreme Court is simply not immune from that. I think it's unfortunate that a lot of those criticisms have been framed in terms of the legitimacy of the court, because I do not think that it is healthy to undermine the Supreme Court as an institution. We need the Supreme Court and the lower courts. There is no alternative in our system to those courts. And I think ultimately a lot of this, to my mind, is unfortunately politically motivated. And I think that the reality with the Supreme Court is somewhat more sophisticated. Yes, we have 6 Republican appointees and 3 Democratic appointees on the court. Yes, they divide along those lines in some, though by no means all, of the most high-profile cases. But yet the reality is much more nuanced than that, and I actually think this Supreme Court term is going to illustrate that. There are some very serious methodological disagreements among the 6 Republican appointees on the court. As I mentioned earlier, I think we're seeing Justice Kagan now breaking off from the other 2 Democratic appointees on the court. It's an easy narrative to say we have a conservative versus liberal Supreme Court, but I think the reality is more nuanced.
Melissa?
So I think it is unfortunate that this criticism exists. I don't think, though, that it is unavoidable. I mean, I think this is a circumstance that is largely of the court's making. And I don't say that because I disagree with some of their opinions. This is a court where we have certain members who are doing things that no other member of a court could have done in our history and been okay. I mean, the idea that you have received an income stream that is virtually the same as your salary on the court from outside sources, that's a real problem. And it's one of the reasons why people, understandably, have questions about whether the court is functioning in a neutral fashion or whether it is an actual political organ. I think its decisions also raise questions. the cases that they take, the fact that the court suddenly decided when it had a 6-3 conservative supermajority to overrule affirmative action and overrule abortion. That's not necessarily because the law was unclear before, it's because they had the personnel to do it, and we're not dumb. Everyone gets that. I mean, so yes, we are a deeply divided and fractured nation, but this isn't simply about disagreement with the court. Some of this is about disagreement with the way power is wielded. Some of this is about the way the judges conduct themselves and whether they are above the law. And just generally, it is a real question for the court because the court, unlike the political branches, has no real way of enforcing its work. I mean, we are in this position right now where the overarching question is, if this court actually puts a hard limit on this administration, will the president comply? That's a real question, and that's always been the question. What has made us comply for the last 250 years is because we believed the court was doing law. When it suddenly looks like they're not doing law, that something else is at work, that's when the court is most vulnerable, and in this particular circumstance, that vulnerability is largely of its own making.
All right, questions over here?
Great presentation. What we've seen recently from the Trump administration engaging major law firms to take a certain position or not take a certain position, and I think your law firm was one of them. Give us a little insight on why you caved, for lack of a better word.
Yeah, so I think I will say this. Thank you, Kim, for mentioning my law firm in the introduction. I should say that you know, our law firm, like others, received an executive order from the president. As I think many of you will know, we ultimately resolved that without going to litigation. And you know, I would just express my own personal view, and this is very much my own personal view. On the one hand, I think all of us recognize that these executive orders raise real issues concerning the rule of law and our legal system. On the other hand, for the law firms that are on the receiving end of this, there are very practical considerations concerning the implications for the law firm's clients, and those implications were very real. And I can tell you that when we were in the vortex of trying to figure out how to respond to this executive order, that I think we all felt the competing imperatives there. And I think we're seeing elsewhere in American life with higher education and other institutions many of the same challenges. And I think resolving those competing imperatives is actually very difficult. And I recognize that on the one hand, in some sense, it's very easy to just think the solution to all of this is, of course, to fight, particularly when you feel as a principled matter that what has taken place is wrong. But on the other hand, I think when you are a leader in one of these institutions, you have to weigh those practical considerations. Your obligations are first and foremost to your clients, and second to your employees, the people who work for your firm. And we obviously came out the way we did. Other law firms have come out differently, and you know, I would be the last person to be critical of those who weigh those considerations differently. I think these are very hard decisions.
All right,
Can I say something?
Yes, very quickly.
I think our real ire ought not to be on those law firms that capitulated. Like, our real rage, anger should be directed at an administration that did this in the first instance. Like, full stop. Like, I am in higher education. We are living under the specter of this. This is not how it's supposed to work. And this was a very targeted move. Like, the administration has limited the availability of legal resources at the same time it is petitioning the Supreme Court to narrow the availability of the nationwide injunction. If the court takes them up on that and narrows the circumstances in which the nationwide injunction is available, it means that we will need to litigate in almost every district around the country to stop the administration at a time when the administration has literally taken pro bono legal resources off the table. Yeah. That's not a coincidence. That is exactly by design. So don't lose sight of that. Like, it is terrible that these choices had to be made. And like, Paul Weiss employs lots of people, not just fancy pants partners, but also like secretaries and paralegals, like people who need jobs. And like, this is the anger ought to be directed where it is justly deserved, and it's not necessarily there.
Cannon, you get the last
I
word.
will say, as we were having discussions about what to do, and as I was advising Brad Karp, the chair of our firm, about what to do, it will perhaps not surprise all of you that my first instinct as a litigator was to fight, as has been publicly reported. I was leading the legal team in our firm that was preparing to fight. And I remember as we were discussing all of this after, God knows how many all-nighters, I pulled more all-nighters that week than I had at any point since college. I remember going for a walk down to Farragut Square and thinking to myself, boy, I really want to fight this. But then I thought to myself, what about Sharon in the mailroom? And what about her son who comes to the office to do his homework? What's going to happen to Sharon if, as seemed like a very real possibility, our fighting this would lead to a cascading effect where clients and potentially partners would leave the law firm? And I tell you what, for all the people who've been rage tweeting at our firm and have been very critical of us, I often think to myself, are you not thinking about these people? And as a leader, you have to think about that. And so again, I think reasonable minds could reach a different conclusion concerning what we did, but I don't think it's illegitimate in the slightest for these institutions, like the higher education institutions, like the law firms, to be thinking about those very practical considerations.
Well, we definitely needed more than 50 minutes for this conversation, but please join me in thanking Melissa and Cannon for this discussion.